Welcome to this introduction to land law, where I'm trying to make the topic fairly simple, just breaking it down to the essentials. Because I know that a lot of students are struggling with the topic, and that's in part due to the textbooks, which are being quite complicated, using really old archaic language, and just wording things in a way that people are going to struggle to understand the things. So yeah, I'm just trying to make it a bit easier for students to understand, and any kind of other people who might want to look at it. So in this session, we just have a look at what is land anyway, how it's defined in law, and what it includes. So what lawyers mean by land. Often when we talk about land in everyday language, it will be, I don't know, some kind of ground, dirt, soil, something like that, where you just have the very basic ground and maybe some kind of plants, but that's the limited view we often have of land when we are talking about it in everyday conversations. In law, actually, there are lots of different things involved in land included in the term, and it's not just the ground, but lots of other things. So it can be physical things like buildings or structures, that kind of thing. It does include things that aren't even physical, like the rights to use the land. So maybe you have the right to walk across a neighbour's land to get to the main road, something like that would be included. Um, and then even things like the right to receive any kind of rents or proceeds, or any money that comes directly from um, owning, possessing the land, that kind of thing. So it might help to think of land as some kind of item that has lots of different layers. So we've got the surface layer, where you've got plants, you've got the garden, a house, pavement, all the things you kind of immediately see when you look at the land. But also it does include a limited um, time area of airspace, so anything that you kind of reasonably need to live and build. So I don't know, just a couple of meters off the ground basically. And for example, if you want to play football in the garden, that would be covered if the ball goes up like a couple of meters high, that kind of thing. It does include the ground below, like foundations, maybe you've got some minerals on your land. It can even include whole mines and that kind of thing. And also some kind of things that are not natural on the land but have been attached, like a built-in kitchen or bathroom fittings, that kind of thing can become part of the land as well, if they are fairly permanent, which we look at a bit later. And yeah, as I mentioned, then we also have the invisible rights, like a right of way, a right to take, I don't know, fish or wood or any kind of things that grow naturally on the land or live there naturally. And yeah, the right to receive yearly payments and that kind of thing. Um, so the statutory definition from the Law of Property Act is quite long and complicated and contains a lot of archaic language that we probably don't really use anymore. But we will just have a look at the different key terms that come up. So the definition is land includes land of any tenure and mines and minerals, whether or not held apart from the surface, buildings or parts of buildings, whether the division is horizontal or vertical or made in any other way, and other corporeal hereditaments, also a manor, a dwelson, and a rent, and other incorporeal hereditaments, and an easement, right, privilege, or benefit in, over, or derived from land. So as you can see, it's quite long, contains lots of terms that we don't really use in everyday language anymore. But if we can break it down a bit further, you should be able to understand what it actually means. So any tenure, that just means that the land usually belongs to the crown and you only have ownership of certain rights. But we look at that a bit later on in more detail. You do have, in theory, ownership or rights to things in the underground. So, for example, any kind of minerals, and if there's coal, for example, these do tend to belong to the person who has the freehold ownership, for example, who possesses the land. But obviously, there are different kinds of rules and regulations which might limit that. So, for example, with coal, that's actually controlled by the coal authority, so you won't actually be able to just open a mine up in the garden. Corporeal hereditaments, that just means any kind of physical, tangible things that come with the land and are lots of kind of intrinsic things, trees, rocks, but also other things that have been added but are fairly like permanent, like buildings, that kind of thing. Then incorporeal hereditaments, that just means any kind of intangible things that you can't touch. So it could be rights over land, like the right to walk across a pathway on your neighbour's land, or rights to take timber or do some fishing, that kind of thing. So if there's some item that is natural in the land, so it could be plants or even like wild animals, then you might have the right to take those to some extent. Then rents, obviously, if you're renting a flat, for example, that would be included. And then there's also some kind of old things mentioned in the definition, like manor and advowson, which you probably don't really need to know. They don't tend to come up in any kind of real life situation very often. And I think buildings should be kind of self explanatory. One thing to note is that land can include just parts of a building as well. So even if you're talking about one apartment or a top floor flat or something like that, maybe even just a single room, in theory that could still amount to be land. Just a little note again on how high and how deep ownership goes. It used to be in many years ago that people thought if you own a piece of land, then your ownership goes as far up to the sky and all the way down to the center of the earth. So you have literally just a slice across the earth and atmosphere and everything included. Now it's only including things that you need reasonably for normal use. It doesn't include just I don't know, building a new mine or I don't know, things like that. Flying an airplane, that would probably not be included. It kind of depends on what's reasonable and what a normal kind of land user should put up with. If there's like, for example, you have a little garden, but there's a crane chip swinging over the garden for months, and you can't really enjoy the garden. It's making a lot of noise. Maybe you're worried that things are going to fall down because they're not secured properly. That could be a problem potentially. By contrast, if you've got a plane really up high in the sky, 30,000 feet up, that's probably okay, depending on how high it really is and whether it impedes you. If it's just a couple of meters above your head and it's like noisy and maybe you're worried that a drone might be like, I don't know, taking pictures, videos, really looking at what you're doing, then that would probably be an issue. So just think about what is reasonable and what might be a bit too much, because it not just balances your own privacy as the landowner with any kind of rights the public might have to use their space, like for example going on holiday, that kind of thing. Another important thing to um, learn about is the difference between fixtures and shutters, because very often the idea is in land law you've got some kind of scenario where you've got an original landowner and they want to sell the property to another person, a potential buyer, and then you need to see what's actually going to happen with the land and any kind of things that come with it. So fixtures, they are kind of permanent things which become part of the land. So for example, bathroom fittings, you'd kind of expect that the buyer just takes them over and they now belong to them. Whereas shutters, they are more like personal items, and the seller is free to take them when they leave. Like for example, your bed, your sofa, your kitchen table, that kind of thing. You'd expect that they can. They're not part of the actual land as such, but you can freely take them as your own kind of personal belongings. So really what we are doing when you need to decide whether something is a permanent fixture or just some shutter that you can remove, there's two questions we need to ask. So one is, how firmly is it fixed? So for example, if there's a kitchen unit that's bolted in and that you can't move, then it's likely a fixture. But if it's more like a rug or a freestanding fridge, then it's likely chatter, so you can take that when you move to a different house, for example. Purpose of attachment is the second and really key test. So why was the item originally attached? So if it was to improve the property, so I don't know, maybe you've installed some really fancy bathroom fittings, some lights, and kind of really fancy shower, that kind of thing. Now, obviously, that improves the property, which likely makes it a fixture. Whereas if it's something that you can easily install and remove, I don't know, for example, you've got the TV where you just plug it in easily and then you can remove it easily as well. So that would probably be a chatter and it doesn't move ownership and becomes owned by a potential buyer. So let's look at some examples and see what you think. Built-in ovens with some kind of inside hob, for example, because they're built-in and hard to remove without causing any damage to your kitchen area and the walls, for example, they are likely to be a fixture. What about kitchen units, wall tiles, any kind of bathroom fittings like the toilet, the bath? Just have a second to think about it. So normally those should be fixtures as well because they're part of the room. So a bathroom doesn't really work without like a shower or a toilet or something in it. They're really kind of intrinsic things. Otherwise, it would not be a bathroom, basically. What about a freestanding fridge? So normally you'd think that is a chatter because it just there may be like a block or something, but otherwise it will just be the own weight of the fridge that's keeping it in place. So that will count as a chatter, and you'll be able to move it when you are moving somewhere. So you can just keep it and take it with you. What about pictures hung on screws? Just take a second to think about it. So normally it will just count as a chatter. You can fairly easily take the picture of the hinges, and even though there might be a screw, normally if you remove the screw it will just leave a tiny little hole which you don't really see unless you're like looking straight at it, so that will probably be fine. It's not causing any kind of major damage. But you could probably think of some kind of scenarios where you've got a picture hanging in, I don't know, castle or old medieval building where it's kind of part of the actual architecture and part of the room and it's like I don't know, everything just don't really work without a picture in there. So in that kind of scenario it might actually become a fixture, but that will be really, really rare. Yes, it's just always the same thing. There will be a general kind of idea, like with carpets and curtains as well. Usually it will be chattered, but you can always think of some exception where it might become a fixture because it's really important to the building and that kind of thing. And it might cause great damage to remove some carpets, I guess. So yeah, that's the kind of thing. Same with like a fancy statue. You'd think that normally it would be chatter unless it's part of an overall architectural design. Maybe you've got like a huge landscape garden with huge statues in each corner, so you can't just remove one of the statue without hurting the overall design. So in that case, it would become a fixture. What about an old um, greenhouse that's kind of starting to fall apart? Would you think that's a fixture or a chatter? Just think about that for a second. So yeah, normally it will be a fixture because it's practically part of the land now. It's been there for a long time, probably. It's difficult to remove it. You probably can't even move any items without causing the entire greenhouse to collapse. So yeah, in that case, it would probably be a fixture, and you wouldn't be able to take it with you when you move house. So just the main thing to keep in mind if you ever get an exam question on that kind of thing, if removing the item would damage the home or the home or room or whatever doesn't function as intended anymore, then it's probably a fixture. But if you can move the item quite easily, then it could be a chatter instead. You might think if you got a exam question, it might help you to come up with a little chart like this, where you have the item, then you check whether each item is attached, how it is attached. Maybe it's bolted in, maybe it's just a plug, maybe you need some plumbings, or it's cemented, or that kind of thing. So that would kind of indicate that it's a fixture, as if it's just held by weight, for example, that would be likely a chatter instead. The other key things to look at is that whether there's any damage caused if it's removed. If there's likely to be any damage, then you can probably assume it's a fixture. If there's no damage, it will likely be a chatter instead. And another key thing to look at is the purpose, so whether it's to improve the property or to make a room function, then it's likely to be a kind of fixture that becomes part of the land. And otherwise, if you have an item that you just use as decor or just something for your enjoyment, like a TV or computer, then it's likely going to be chatter. Right, so let's move on to some of the other key terms we've seen in the statutory definition. You might remember I told you something about tenure. So what is meant by this is that since 1066 the crown is the ultimate owner, so basically the actual real owner of any kind of land property will be our monarch, so King George, for example. What you have if you buy a land, you purchase some kind of property, then it's really just some kind of rights in the land which you possess. It's not actually ownership of the land. But obviously it's highly unlikely that the monarch would ever come and try and take the land away from you. So in modern kind of language, it's still fine to just say that you own the land, even though in the back of your mind you might want to remember that actually the Crown might have higher rights to the property than you have. Um, we distinguish between two kinds of property rights. So on the one hand, we have estates. So that means the rights to possess the land for a time. So if you look at the property market, maybe you go on Rightmove or any kind of thing, and you want to buy a property, then that's the kind of thing that you will get. And it comes in two main different categories. One is a freehold, or the old term for it that will often come up in the statute is a fee simple absolute in possession, so quite long term. It just means that there's no time limit to your rights, and potentially you can hold that property forever. By contrast, if you have a leasehold, which is also called term of years absolute, that means you might have exclusive possession of the property for some time, a limited time that's clearly defined, so a week or 10 years or even 900 years. That's the kind of amount of time that you or then other people that might inherit the property from you are actually allowed to hold a property. And apart from the kind of things that you can like purchase on the property market, we also have interest, so rights over the land that somebody else owns. So examples could be a right of way, or the right to cut some wood, maybe take fish, maybe you have a gardener that's allowed to take some apples or anything they harvest. Then we obviously have very commonly mortgages. So your bank might have a right in that land if you borrow money from them. And then we've got things like a right of entry, that kind of thing. So those will be not normally kind of rights where they can occupy the place as such, but they will have some kind of more limited rights to use the land in a certain way. And those rights can be legal, for example, which means they're quite strong and enforceable, and they will bind any kind of potential buyer that comes along. Or sometimes they can be equitable, so they will be less powerful and which might be protected by the courts, but that depends on lots of other things, obviously, like I don't know whether it's a controversial thing to do. And yeah, we have a look at what can be legal and equitable a bit later on. First, I just want to look again at the distinction between freehold and leasehold. So freehold, even though the crown actually owns the main kind of thing, is the ultimate owner, a freehold is as close to owning forever as you can possibly get. You can kind of give it to your children or whoever when you die, so it's definitely an inheritable right. But since the ultimate owner is the Crown, that is who will take possession of the property if you die and you don't have any heirs. Then the other option would be the leasehold, which you control only for a period of time. So, for example, if you're renting out a flat, you have the exclusive possession. The landlord isn't allowed to come in at any time without any kind of announcement. Then that will likely be a leasehold where you have possession, but there needs to be a specified time period normally until the term ends. Fixed term lease, again, that needs a clear end date. So, for example, you're leasing a property or part of a property, like just a shed or something like that, for a specified period of time. And then last we've got periodic leases, where you have a lease that just rolls on automatically. You're allowed to just stay in there, use the property until someone gives notice, and then the lease will end and you will lose your rights to use the land. So the main thing we will obviously need to look at will be considering whether a certain right in the land is legal or whether it's just equitable. A lot of exam questions revolve around this central theme to decide whether a buyer is bound by the right or not. So a right can only be legal if it fulfills certain conditions. So it needs to appear in the Law of Property Act under sections 1, subsection 1 or 2. If it's not included in that part of the law, in that statute, then it cannot possibly be legal. And then, of course, there's always some kind of necessary formalities, whether it needs to be in writing, for example, whether it needs to be signed, whether you need witnesses, that kind of thing. But for the purposes of this introductory session, we just have a look at things that are included in the statute and which are capable of being legal, subject to any kind of formalities. So this is what the Law of Property Act will look like. It tells you which kind of things are capable of being legal. So the first section marked here in red will obviously tell you that estates and land can be legal. So that will be a freehold, which is the term for number A, an estate in fee simple absolute in possession. That's the old archaic term, or freehold, just a more common term. And the second type of estate that is capable of being legal would be the leasehold, or otherwise a term of years absolute. So we've already covered those in the previous slides. Then the green part lists 5 different items which can also be legal, even though they're just interests in the land of another landowner. Easements, rent charges, legal mortgages, that kind of thing. So let's just have a look at those in a tiny bit more detail. Easements and profits, they have to be for either forever, so that's one option, or for a fixed term that's kind of specified. If the duration is uncertain, so for example, you say as long as you need it, or another common one would be as long as this person is alive, that kind of thing, because you can't really pin down the exact duration, then it will not be able to be legal. It might still be equitable, so you might still potentially be able to enforce it, but it will just not count as legal. Then another thing that might be legal is rent charges. So that would be the right to receive a periodic sum from the land. So maybe you've got a right to have a yearly, I don't know, kind of sum paid, or it might be every 10 years, something like that. That would be a rent charge. Then a really common one, as I said, any kind of legal mortgages where you need money from the bank to buy the property. Then obviously the lender has a security over your land. They are technically the actual owner, and you just have possession rights. And if you default on any kind of payments, then the bank or other kind of lender can take the property and sell it to just get the proceeds and make sure they don't lose out on any kind of money. Then we've got statutory charges, so that might possibly happen, like any kind of rights created by a statute. Maybe it's I don't know, is a tax or a legal aid charge, or maybe rights that a spouse or partner might have over the family home, that kind of thing. And lastly, rights of entry. So those are a bit similar to mortgages in that they apply when you are defaulting on any payments or breaching any kind of parts of your tenancy agreement, that kind of thing. So in that case, your landlord might be able to retake the land if you're just not paying your rent that's due every month. So we just have a look at a bit of an example to illustrate this and make it a bit clearer. As I said, a lot of questions in land law will be considering a property that's being sold, or maybe there's a potential buyer, and then you need to decide which kind of rights are actually binding on the purchaser and which ones they can probably ignore. Let's just look at the example here, number 12 Sunflower Street, which is a small house with a driveway and a little garden. So the original owner is Maya, and she's got a freehold ownership. So basically, Maya holds that property forever, and then if she dies, it might go to any people who inherit her property. Now, Maya has done a couple of things which affect the property, the land as such. So firstly, in order to buy the property, she needed a loan from the bank, which is, I guess, really common. So the bank has a mortgage over the house, which is their kind of safety net. If she stops paying the sum that's due each month, then they can obviously retake the property and sell it, for example. Then the second thing that Maya has done is she rented out the garden flat to Tom on a 2-year lease. So she had a little like house garden shed, something like that, and she rented that out to Tom for 2 years, and is like receiving some kind of rent from him in return. Tom has exclusive possession of the land, so he's the only person that is allowed to use the flat, and Maya cannot just enter the flat at any time as she pleases. Then third, Maya has also signed a deed to allow her neighbour Sarah to walk across the driveway to reach her bins. So that's obviously not quite as substantial as renting out your flat, but it's their right to use the land. And because it's a right over someone else's land, Sarah doesn't own or possess or hold the property in any way. She just has some kind of agreement with Maya to use the land. So that would be an easement. And lastly, Maya has a partner, Leo, who helped her with the deposit. He actually gave like half of the deposit that was used to get the property, but his name doesn't come up in the deeds, the contract as such, so he didn't really sign the contract as such, and he's not listed as a real owner, but he still has an interest in the land as such because he is living there, he's paid the deposit, maybe he's making some other expenses like paying for any repairs, that kind of thing. So that would still be recognized in equity because that's just what fairness requires, really. So let's just think that Chris might now consider to buy the property. Which of those rights would be binding and which can he probably ignore? So let's have a look at that. As we can see, Maya is the actual freehold owner, the kind of person who has possession rights, but there's also lots of other things that are existing at the same time, other rights. So that would be the mortgage with the bank who's given her the loan. Then we've got the lease of the little garden flat. We have the easement to use the driveway and walk across that. And we've got obviously the funding with the deposit that's giving her partner some beneficial rights to use the land as well. So if we have a problem question like that, we need to basically look at three main questions. So one, what is the nature of each interest? Two, is the right legal or equitable? And three, has the right been protected by any kind of measures? So firstly, what kind of right is it? So we just need to decide which label fits the best. So is it like a right to possess the place, like exclusive possession? You can shut out any kind of landlord, for example, or is it just a kind of permission to use the land in a limited way? So the bank mortgage, obviously, that is security for a loan. That's something really substantial, and that's definitely capable of being legal, as we've seen from the statutory definition. Then we've got Tom's 2-year lease of the little garden flat. So that's likely going to be a leasehold estate, which is kind of time limited. We've got Sarah's path across the drive. As we said, that's going to be an easement, so the right to just use the land. And lastly, we've got Leo and how he helped with the deposit, and that's going to be likely to be an equitable beneficial share that he has, so he's protected out of like fairness reasons by equity, even though as such the right doesn't amount to a legal right. As a kind of rule of thumb, legal rights are the kind of formal heavyweight ones, which need to be created by a deed and often registered. And then equitable ones are more recognized by fairness, where there's not really any major formalities. But you obviously learn about that a bit more in equity, and also other areas of the law. So that kind of tells us mortgages will usually be legal. Leases can be legal if they are created with the right kind of formalities. So if it's a long kind of lease, or more than 3 years, then you will need to have a deed. Whereas if it's a short lease, like here, under 3 years, then you don't necessarily need any kind of written document, and it will still be legal even without those formalities. Easements can be legal if they're created by deed. If they're not created by deed, then they are just equitable. And then we've got obviously any kind of shares by helping with the purchase money, helping with the deposit, that kind of thing. They will most often be like a trust and just be equitable. But of course they're not protected by a deed or any legal rights. So will a buyer be stuck with any kind of rights? It depends on the formalities quite often. So has it been registered in the land registry? Are there any kind of deeds, that kind of thing? Are they currently occupying the house or part of the building? That kind of thing. We don't really know a lot about that just from the little kind of scenario, but often in problem questions you have a long kind of history and explanation and that kind of thing, you be able to work it out in more detail. So just a little overview of the types of interests and whether they are likely to be protected. I guess it's fair to say that most likely to be protected and binding on Chris as a purchaser will be the mortgage, will be the lease to Tom for the 2 years, and can also possibly, if it's been registered, the rights of Ray that Sarah has over the land, or if she's been using it for a long time and nobody ever complained, that kind of thing, that might be protected as well. And then potentially also Leo's interests, if he's in occupation, he's actually there, he's using the property, then he might be protected as well, out of fairness rather than it being a legal right. So Chris, what he should do is to just check the register and see if there's any mortgages, registered leases, that kind of thing, to really be clear which rights are binding or not. He should definitely check whether any kind of people are living there in actual occupation. Is Tom living there in the garden flat, or is Leo living in the house? because it's their kind of family, matrimonial home, for example. So he should have a look at that and get a solicitor to confirm so he knows which rights are actually binding on him, which he needs to look out for, and which he can maybe ignore. So last, let's just have a little quiz to check your understanding. So first question, does land in law include buildings and parts of buildings? So the answer should be A for yes. If you go back to the statutory definition, definitely mentions buildings and parts of buildings. So those are included in the land that you might purchase, for example. Which is more likely a fixture out of the two options here? So either a built-in oven or a freestanding fridge. So the oven, because it's built in, it's been fitted, it's probably difficult to remove, might cause damage if it's being removed, that would be a fixture, whereas a freestanding fridge, that's just maybe plugged in, but you can remove quite easily, that would count as a chattel. Then we have the next question, what is a freehold in plain terms? So A is a 12-month tenancy, or B, ownership without time limit. So the correct answer here should be B. So that's as close as forever as it can possibly get in English law, and you're just the owner without any kind of time limits on your possession. Now, what is a periodic tenancy? A bit more of a tricky question, I guess. Is it something that renews each period or fixed end date? So that should be A. It's just some kind of lease that renews automatically without any kind of formalities, and the time can be quite variable, might be it renews every week or every month or even every year. Then we've got just a couple more questions. What is an easement? Let's have a look. So it should be a right over a neighbour's land. B. Next question. Do you own airspace to infinity? Which we've covered. So it should be B again, only as needed for normal use. Then next question, so we're just looking at fixtures versus chattels. So what is the main test there? Is it purpose of attachment or original purchase price? And it should be the purpose of attachment, so whether it's been used for enjoyment, for example, like a TV or a computer that's just plugged in because you want to use it, or whether it's been used to improve the property, or maybe just because it's necessary for a certain room to function, like bathroom fittings, then that would be a fixture. What are profits à prendre? We haven't looked at those in detail, but you might remember that it was mentioned on a couple of slides, and it should be A, the right to take natural products like wood, like fish, like I don't know, apples growing on the land, that kind of thing. Then we've got last question, when can easements be legal? And we're looking particularly at time requirements. And the answer should be A, because it's either forever or at least a fixed term that's clearly definable, like a number of years, for example, if you say like it's for 20 years, 30 years, that kind of thing. Whereas if it's an uncertain duration, that's not easy to define. Maybe it's a really vague description, like for as long as you need it, for example, then it will only be equitable. Right, so that's the end of the session. I hope it helped to make things clearer, and I see you in the next video.